Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
All right, today I'm at Moranbah Magistrates Court, about 2.5 hours west of Mackay. Client had 2 offences, 2 charges of drink driving. The first was a reading at .045 while on a P-plate licence, so he had a permitted blood alcohol concentration of 0. And then a couple of weeks later he was done again, high range drink driving whilst on Ps with a reading at .201. So 2 separate charges. First, as I said, .045 when he's got a permissible blood alcohol concentration of 0, and the second of .201 again with a permissible blood alcohol concentration of 0. The charges themselves were obviously quite serious, but what aggravated the matter was his history. He did have a previous .131 and multiple charges of disqualified driving in his history. Fortunately, this time there was no disqualified driving. Had he have been charged in the opposite order, meaning the .201, then the .045, there would have been a disqualified driving, because if you get charged with what's effectively low-range drink driving, you'll get a 24-hour disqualification, and then you can keep driving up until the matter's finalised. But if you're high-range, which .201 is, you are off the road completely until the matter's finalised. So had he been charged with the high range first and then the .045, he would have also been charged with disqualified driving, and given he's a repeat disqualified driving offender, jail would have been almost a certainty. Don't get me wrong, I would have gone in guns blazing trying to avoid it, but some form of jail would have been a certainty. I mean, I would have endeavoured to get immediate parole or some kind of imprisonment that didn't involve actually going into jail, but again, had he been disqualified, it would have been guaranteed. Given that he wasn't disqualified, it didn't mean that jail wasn't guaranteed. I still had to dig deep to endeavour to make sure that didn't happen. And again, given it's on his Ps, 2 drink drivings in a fortnight, and one of them being very high range, .201 with a previous .131 and multiple disqualified driving, my job nonetheless was still one of avoiding imprisonment. With clients who are facing a high risk of imprisonment, I draft extensive summaries of the relevant case law. When I say case law, I'm talking about previous matters in higher courts, so the district or the Supreme Court, where the person in question has got a similar, if not worse, history and circumstances of offending than my client. So the reason I do that is so that I can say to the magistrate, look, yes, this is grossly out of line offending and grossly out of line history, whereas here's examples of other persons with grossly out of line offending and grossly out of line histories getting outcomes similar to that which I'm seeking. So what I'm getting at is this wasn't about his licence, this was about avoiding imprisonment, and with regard to his licence, he was going to be off the road regardless for quite some time. Again, given his history and given the readings and the fact that they happened so quickly in such a short time frame. Again, I drafted those written submissions, emailed them to the court and the police in advance. I got my client to do a reformatory course. Well, I asked him to do it, which exposed him to what can happen when you drink drive, death and injury, and it's quite full on. These courses that I send my clients to, it's not just videos and light pro presentations. They get persons who have lost loved ones or suffered physical injuries themselves as a consequence of collisions with persons like the client that I acted for today. I asked him to get character references based on a template that we provide all of our clients, and as I said, I prepared those written submissions in advance, emailed them to the court to give both the court and the police the opportunity to consider them and respond appropriately to them. I made verbal submissions centering around the fact that I didn't want my client to go to jail. So I basically said to the magistrate, with regard to his licence, that is the least of his concerns, and I said that to my client going in. But that said, obviously, in a regional location like Moranbah, and if you work in mining, which everyone does, including my client, the longer you're off the road, the longer you're going to suffer financial hardship. And my client was mortgaged, so there's every chance he'll lose his house, irrespective of the length of a disqualification. But obviously, he would most certainly lose it if he was jailed. But there's certain characteristics that are unique to persons in regional locations that just aren't present in the CBD of Brisbane. I actually wrote an article that was published in the Courier Mail about a month ago, talking about work licences. I mean, my client wasn't eligible to apply for a work licence because he was A, high range, B, on his P's, C, second in 5 years. But persons who are eligible, if they live in Moranbah and they lose their licence for 6 months, they'll lose everything. But if you're an IT professional who lives at New Farm and gets the ferry to the city each day and he gets 6 months, you just can't visit your mum on the weekend. How's that justice? I mean, how is that a fair application of the law if one person is financially wiped off the map and the other just doesn't get to party on the weekend? Anyway, I'm going off point. I made those submissions to the magistrate about comparative cases and why, if those persons didn't get actually sent to jail, perhaps it's appropriate that my client doesn't either. But again, with regard to his licence, I did effectively, I didn't remain silent, but I didn't put a number or bracket to the magistrate. I just said, look, my purpose here today is to try to persuade Your Honour not to send my client to jail, meaning that my client and I both get to leave the courtroom together. And the longer he's off the road, the longer he's going to suffer financial hardship. And I left it at that. Anyway, I'm sort of prattling on a bit now, but the short version is I was successful in avoiding imprisonment completely. So I'm not going to give a breakdown on the different forms of imprisonment that can be handed down, but other than to say that not all imprisonment means actually going to jail. You can be wholly suspended, you can get immediate parole, and there's a whole gamut of options available to the magistrate that are technical imprisonment, but don't actually involve locking a person into a cell. But that said, there was no imprisonment of any kind. There was no actual imprisonment, no suspended term of imprisonment, no immediate parole. He was disqualified, obviously. It was a total of 18 months, which, like the worst case is a lifetime loss of licence for one charge, let alone two. But as I said, I always say to clients who point to it over that if I can get under a year with absolutely no previous, that's a great outcome. The fact that he's got 18 months for two offences with lengthy previous, in my mind, is a very good outcome. But at the end of the day, my client didn't go to jail, so he's very happy. So no jail, 18-month disqualification, modest fine. Client's clearly relieved, given he's going home. I'm Andrew Wiseman. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment, or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road.